Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with confessing to a crime that was not committed. Let's see here. Let's see. My son is accused of a murder that he did not commit, but they have already made him confess. Well, wait a minute here. Well, obviously, the obvious question is, why would he confess to something he didn't do? Was he trying to protect somebody else, a family member, girlfriend? It doesn't matter. That's going to have to come out eventually, and of course, the jury is going to have to buy it. That's the other issue. Now, the other potential reason why he may have confessed would be because he may have felt intimidated. If, for instance, let's say the police physically threatened him with great bodily injury or death, or if, let's say, they hypothetically brandished their firearms, that would be the basis, for eliciting a false confession. Now, if it comes to simply, lying to him about the criminal justice system or facts of the case or the law, that's not a basis for saying, well, I confessed because I felt intimidated or because they lied to me. Remember, the police, they have the right to lie to you to get information out of you. Generally speaking, police statements, just what they say orally is generally not enough to defend yourself from a false confession. Now, the other thing that could be an issue is your mental state, or your son's mental state, rather. And if that's the case, we may have to ask for a psychological evaluation under Penal Code Section 1368, where 3 psychologists would come to interview your son, and they would make a determination as to whether or not your son was aware of the consequences of his actions, namely making that confession, or if they make a determination that your son is so bad mentally that he cannot assist in his own defense. That would also be a basis for your criminal case, or your son's criminal case, to be suspended and for him to be sent to a special hospital where he would be treated. And if he is rehabilitated, then we could proceed with the criminal case. At the end of the day, if he is of sound mind, and if there was no real intimidation from the police, and if he flat out confessed to this, well, then this is going to have to be argued before a jury. They're going to have to bring in 12 people from the community. They're going to have to listen to all the evidence, and then they're still going to have to decide whether or not your son is innocent or guilty beyond reasonable doubt. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.